Hello everyone, and welcome to Fieldfisher's 14th Data Protection Day video. Today we've decided to do something a little bit different. We've asked you all for questions and we're going to try and answer as many of those as we can. Unfortunately, we had far too many for this short video, so we will be getting back to you separately in other Q&A sessions later in the year. If you have an urgent question that we haven't managed to address today, please do email us. My name is Hazel Grant. I'm the head of Privacy, Security and Information Law at Fieldfisher, and I head up our team in the London office. We have a number of experts across all of our offices in Europe, Silicon Valley and China. We are a collaborative team providing strategic and actionable privacy solutions for our clients, and I know you're going to see that and hear about that in this video. So let's get a start on the first question. If the EU makes an adequacy determination in relation to a country, let's call it country X, and let's assume the UK gets its own adequacy finding from the EU in the next 6 months, does the UK automatically recognise country X as adequate?
Well, the short answer is no. It's true that at the end of the Brexit transition period, when GDPR was turned into the UK GDPR, the UK government, the UK Parliament legislated for automatic recognition of existing adequacy decisions. It's in the new Schedule 21 to the Data Protection Act. However, there's nothing which looks forward and says that the UK will automatically find a determination of adequacy in relation to any EU future determined country. And in many respects, it would be strange if the UK were to do so. If there's a point of Brexit, it would have been to take our own path in terms of international trade. So it would be strange for the UK to just simply follow the EU in these activities. However, on the other hand, the UK will not wish to put UK businesses to too much of a competitive disadvantage in relation to EU competitors. So who knows?
How are other clients CCPA-proofing their supplier contracts in the same way that was done for GDPR?
When you think about CCPA-proofing your supplier contracts, you need to think differently than we did when we were dealing with the GDPR. We all know that Article 28 required certain contract terms be in place whenever you had a controller to process or transfer, but that's not how the CCPA works. So when you're thinking about CCPA language for your supplier contracts, there's two questions that you need to answer. The first one is, do you need any language in there? And then the second question is, if you do, what does that language need to be? The first question is really the harder one to answer, because the CCPA doesn't actually require any contract language at all. What the CCPA does say is that if you want to be able to transfer personal information to somebody else or make it available to somebody else, and you don't want that transfer to be considered a sale under the CCPA, one way you can keep it from becoming a sale is by transferring to a service provider. Now, service provider is defined as requiring certain language be in the contract with the service provider. So the only time you really need contract language under the CCPA with a service provider is when you are trying to transfer or make information available to that third party and not have it be a sale under the CCPA. There's certain other things you need to think about as to whether or not you need that service provider language in there, but that's the essence of it. Once you know you do need to have service provider language in your contract, you need to look at the definition of service provider in order to know what that language needs to be. Again, unlike the GDPR, the CCPA is very clear that a party is not a service provider unless the written contract has certain prohibitions on how that entity can use the personal information. So if you know that you need to have that language in your contract, you need to look at the definition of service provider. In that definition, and that's in section 140V of the CCPA, it tells you exactly what the contract needs to prohibit in order for that party to be a service provider. So if you do need to put service provider language in, follow the language of the definition as closely as possible. Now, how clients are doing that as a mechanical matter is that they are addending or updating their contracts where they're not comfortable that their existing contracts contain language that matches closely enough to the definition of service provider or doesn't cover off transfers that involve the personal information of California consumers, California residents. But essentially, that's how our clients are looking to embed the CCPA in existing service provider contracts. First of all, figure out whether or not you need CCPA language. And if you do, second of all, look at the definition of service provider to know what that language needs to be.
Given the Schrems II decision, is it true that a US-based multinational will need to update all of our data processing agreements with our customers who rely on us for processing clinical trial data? Note, we are the data processor and our customers are the controllers. The data subjects for the clinical trials may be from the UK or from the EU. The processing happens on a US-based cloud.
I think the focus of the question on clinical trial data might hide the fact that that is a general problem. What we have is a US-based processor whose customers in the EU are controllers, and the controllers of the data are ultimately transferring data outside the EU to the US. The Schrems II decision did indeed say that whatever method you use previously for legitimizing that transfer, and typically it would be a standard contractual clause mechanism, that they may not be enough on their own. A risk assessment is needed, and in many circumstances, perhaps all circumstances when the recipient is in the US, you need to consider supplementary measures. And indeed, we're helping loads of clients put in place supplementary measures right now. The position is the same for the UK. The law is the same in all material respects. In relation to clinical trials, and it does sound like the company asking the question might be a CRO, perhaps not. Clinical trial data is typically in the hands of the processor or service provider CRO, key coded, and might be, will be considered pseudonymized data under GDPR. But pseudonymized data remains personal data. And so the analysis I just set out still applies. So unfortunately, the short answer is yes, you will need to revisit your data processing agreements with customers, or at least your customers will need to revisit them with you.
Is there a benchmark or another common criteria or set of reference points for an average size of a data protection organization in a large Stoxx listed company, in particular for a European energy group?
So that is a good question. We haven't quite hit a universal standard yet, but possibly the closest thing we have to a data protection benchmark from a regulator is the UK Information Commissioner's accountability framework and toolkit that was published back in autumn last year, autumn 2020. This framework breaks down 10 different data protection control areas, ranging from governance structures right through to policy, through to breach management, training, privacy by design, data subject rights requests, etc. And it sets them out at quite a granular level on how the ICO expects organizations to show their practical compliance with data protection regulations. And the framework comes with its own self-assessment, and you might like to use that as a good starting point to benchmark your own organization. Outside of that, there are a number of other frameworks that you could also look to that have developed over the years out of some of the older risk management frameworks. So for example, ISO 27001 and NIST security frameworks have developed kind of privacy bolt-ons over the past year or so. And you could also look to some of the privacy tech vendors, and you probably know the ones I'm thinking about, who build in a lot of these, these data protection reference points into their technology. And of course, you could, always opt for a good old-fashioned external audit, against any of these frameworks or a particular area of data protection if you had concern. But if all of this is starting to feel a bit overwhelming and you don't have the resource to add these frameworks, you could start by developing your own key performance indicators or KPIs, metrics, to start tracking how you're doing yourself. And obviously you'll need that kind of information if you're going to benchmark yourself against some of these external frameworks anyway. So for example, are you tracking the number of data subject rights requests you have? Are you counting how many days it takes to fulfill them? Are you tracking number of incidents, number of contracts reviewed, percentage of people that are undergoing data protection training? I mean, all of these are kind of key measures and good starting points to measure yourself. But I think if I was going to pick one external benchmark to measure yourself against for the first time, I think I would go with the ICO framework.
What type of consent is needed for direct marketing via in-app messaging and push notifications?
Well, the consent requirement in the Privacy Directive and the related UK regulations turns on the definition of electronic mail. So opt-in consent is needed for the use of electronic mail for direct marketing purposes, except in very limited circumstances. And the Draft Information Commissioner guidance on direct marketing refers very briefly to the e-privacy rules applying to certain types of communication in a direct marketing context. And it suggests that in-app messaging and push notifications are covered, but it doesn't, unfortunately, provide any further detail. Ultimately, whether the rules apply turn on whether the message or notification fall within the definition of electronic mail. In other words, whether the message or notification is capable of being stored and later retrieved. If so, then the consent requirements are triggered in respect of the notification or message, assuming that it relates to direct marketing.
How do you see the data transfers to the UK? Do UK national surveillance laws hinder data transfers?
Now, the question here obviously has in mind the Schrems decision, where the court held that standard contractual clauses alone could not actually necessarily protect European data in the US because of FISA and US surveillance laws. And could that same criticism be levied against the UK? Well, the short answer is yes. However, there is a political will in the EU, as well as the UK, of course, for that not to happen. And that political will is manifested by the agreement as part of a trade deal that the EU-UK will carry on discussing adequacy for the next 6 months, and people do expect the UK to be granted adequacy. And if it does get granted adequacy, then this question just simply doesn't arise, because you don't have to put in place Schrems-inspired supplemental measures for transfers to an adequate country.
Under the EU GDPR, would an employee working from home outside the EEA constitute a restricted transfer?
The question is asking about whether or not it is a transfer within GDPR for the data which is in the EU to be made available to an employee outside the EU. And the question stipulates that they're working from home. So it's some form of permanent arrangement, and not just the more difficult issue of an employee on a business trip or an employee on vacation accessing server back in the EU. Now, the European regulators have always taken the view that access to data which is stored in EU from outside the EU is a transfer, and it will make no difference to them that it's an employee of the same organization. It is still a transfer. In the end, you could see the employee working from home outside the EU being an office or establishment or a branch of the European entity. The question has got the pandemic in mind, temporary arrangements, then that might be a different question, a different issue. But ultimately, I think regulators will see a permanent activity of this nature as requiring standard contractual clauses or some other adequate safeguards. Or the organization, of course, seeing it's only a single employee, might take a risk-based approach to the issue.
We are a software company. Our product is a lead capture app with cloud storage. Our infrastructure is based in the UK, but several ancillary software services we use, such as Basecamp and Slack, etc., are US-based. Due to the collapse of EU-US Privacy Shield, do we need to enter into the SCCs with our EU clients? Also, many of our clients are US-based. Will the SCCs be required for them as well?
The software company here is based in the UK. The infrastructure is there. I'm assuming that they contract from a UK entity, and therefore they're subject to the UK GDPR. Now, when they contract with EU clients, I'm assuming again that the EU clients are controllers of the data that the EU clients put into this cloud solution, and that the software company is a processor. So indeed, the EU clients are transferring data to the UK, and they will have the responsibility of satisfying their obligations on cross-border data flows, the UK now being a third country. Now, of course, for the time being, because of the trade deal that was agreed at the end of last year and the 6-month moratorium on trade data transfers between the EU and the UK, nothing needs to be done immediately, and the UK may well get adequacy in that 6-month period, and that is widely expected. So SCCs will not be needed for the transfer from EU controllers to the UK now, and likely not at the end of the 6-month period, subject to there being an adequacy finding. In relation to whether SCCs are needed with US-based clients, well, if you're a processor in the UK sending data back to your controller customers outside the UK, that is a transfer of data outside the UK. So strictly, you will need some form of standard contractual clauses to satisfy your own UK GDPR responsibilities. The problem is that at the moment, there are no standard contractual clauses which cover that situation, processor to controller. The EU new standard contractual clauses, which are out for consultation at the moment, will fix that problem for EU processors, and it remains to be seen whether the UK will also adopt those new SCCs when they are, some point in 2021, finalised by the European Commission.
What is best practice for responding to DSARs when you can't easily identify an individual, you just know their cookie ID?
Well, obviously, the starting point is that you need to be satisfied that you know the identity of the requester or the person on whose behalf the request is being made. And if you're unsure, you can ask for further information to identify the individual's identity. The key point is that you must be reasonable and proportionate in what you ask for, so context will be important. And the level of checks that you make is likely to depend on the possible harm and distress that inappropriate disclosure of information could cause to the individual concerned. So if the output is likely to be that you will be revealing some innocuous customer segments in which the ID appears, then the lengths that you would go to verify ID might not be as great in those circumstances as it would be in other situations. Approaches are likely to vary from a fully automated approach that identifies the browser from which the request is being made to looking for some kind of documentary verification that a particular ID, such as an advertising ID, relates to an individual. So for example, asking the individual to provide a screenshot of the advertising ID or some kind of statutory declaration.
If enacted, will e-privacy cause as much trouble to different market actors as the GDPR?
Well, it's certainly likely that the e-privacy regulation will have a significant impact on certain actors if it's enacted. For example, it seems that the rules on security and confidentiality of communications will extend beyond the traditional telecoms providers to over-the-top providers, so internet-based communications services. On the other hand, at the moment, it's looking likely that there will be some good news for businesses in the cookie consent context, because it's looking likely that first-party analytics cookies will not require consent, and neither will third-party analytics cookies, as long as the analytics provider is acting as a processor and as long as certain mandatory contractual provisions required by the GDPR are in place. Under current provisions, it's also looking likely that there is potentially a wider impact in a business-to-business direct marketing context, because it's looking likely that consent would be needed to send direct marketing by electronic mail to a natural person, even if it is in a B2B context. So if sending a direct marketing email to a business email address of a particular individual rather than to the company email address, such as info@abc.com, then consent would be required. So that has potential implications, for a wider range of actors. But of course, the draft regulation has already changed a number of times, and it's likely to do so again.
What is your view on the future of the EU-US cooperation regarding privacy and data protection? In the light of legal, cultural, and political differences, do you think that a transatlantic regulation of privacy is a viable solution, or rather is it just a utopian vision which should not be taken into account anytime soon? Following on from this, what is your opinion on the prospects of federal privacy regulation in the US?
In light of the recent Schrems II decision, we're all looking at additional complications and additional requirements where we're dealing with data flows with the US on the one hand and the EU and the UK on the other hand. So the question has to do with future of cooperation between the EU and the US. The short answer is that there is going to have to be a solution. There's too much data flowing back and forth across the Atlantic, and there are too many EU and UK companies that rely on US providers and US companies to handle that personal data. We've already seen the US Chamber of Commerce issue a white paper in response to the Schrems II decision and try to demonstrate from the US side why the issues that cause the concern for the Schrems court really shouldn't be causing that level of concern. But all that shows is that the US and the EU do have a future finding a path forward, because there simply has to be a path forward. There's too much data going back and forth, and I think we just need to be a bit more patient and see what that solution looks like. In terms of federal privacy legislation in the US, obviously we now have the CCPA as law, and we've seen the problems and the cost to companies to enact the CCPA. There's now going to be additional requirements added to the CCPA as a result of the CPRA, and we're seeing other states now introducing privacy legislation that's going to be different than, and slightly different than, or greatly different than the CCPA and the CPRA. So the need for a consistent legislation at the federal level in the US has never been more clear than it has right now. There have been numerous efforts ongoing in Washington, D.C. to try to craft a federal law at the federal level. The idea is that a federal law would then preempt or override each of those different states' laws, and that companies would only have to deal with the federal law and not have to worry about the different nuances in different states' laws. Given the fact that we now see the real cost to companies to comply with the CCPA and the cost to comply with the CPRA, chances are pretty good that there will be legislation at the federal level. It's just going to be a question of when.
What is your advice for adequate data mapping exercises for in-house companies with little buy-in from other stakeholders?
Yeah, so I can feel the pain in this question. This can be quite a common issue, getting buy-in from various stakeholders who don't, either have the time or inclination to help with, data mapping exercises. This is unfortunately quite common. So I'm going to assume that you're struggling with the kind of, front-end data mapping exercise that, maybe you're not getting responses to data mapping questionnaires that you've sent out to various stakeholders. And certainly, I've had experience of that in the past, and I've generally found that the either face-to-face meetings, when you can do that, or calls are a much more productive way of getting responses to those questions. And it gives you an opportunity to explain why you're doing it, and makes it much more of a two-way conversation. But if you're struggling to get that and struggling to get any kind of human response, then the only other real way of doing this is tackling it via the IT backend. And you may be aware, but if not, there are a range of privacy tech vendors out there, as well as e-discovery or forensic providers that offer data discovery type technology, which essentially just scans and analyzes data sets for personal information and catalogs them, or for other types of data as well. This doesn't leave you completely stakeholder free, as you will almost certainly need IT support with a project of this kind, and obviously it comes with a dollar or pound sign cost attached as well. So I'm afraid I really don't think you can escape stakeholder engagement, as data mapping should be a continuously evolving project. It's not just a snapshot in time. So I would, I think if I were you, I would certainly try and prioritize your stakeholders by potential data protection risks. So for example, I would certainly be focusing on HR teams. I'd be focusing on teams processing client data, as a starting point, and keep working on them with some carrot. Buy them a coffee when you can get back into the office. But in all seriousness, I would also use quite a bit of stick here as well. Data mapping is an essential precursor to developing and maintaining your records of processing, which I think probably all know at this point is one of the first things that a regulator will look for and audit in the event of a serious data breach or incident within an organization. So if you're still not getting stakeholder engagement even after pointing out these things, formally document it in a risk register if you have one, or formally report it to management. And and if you're not able to get data mapping done, at least you can fulfill your accountability obligations to explain why it's not being done and to document it.
What is there to do about transfers from a US controller to US or other non-EEA UK processors where the US controller is subject to GDPR? And the questioner says, Article 28 plus C to P standard contractual clauses.
As a result of the recent Schrems II decision, U.S. data controllers that are subject to the GDPR can no longer rely on Privacy Shield for data transfers. Something has to be put into place to bridge that gap. And for most U.S. data controllers, the only realistic option is going to be some form of model clauses. Now, the existing model clauses, both the C2C and the C2P versions, both assume that you have an EU data controller who is the data exporter. Obviously, the current model clauses didn't anticipate or didn't take into account what is in the GDPR Article 3.2, which is that you can have a data controller who's located outside of the EU, but still subject to the GDPR. We know that the model clauses haven't kept pace, and that's why we have updated model clauses on the way and hopefully on the way soon. But in the meantime, if you're a US data controller, what do you do if you previously relied on Privacy Shield? The short answer is you're going to have to put some form of model clauses in place, even if it isn't a perfect fit. This has been the situation for a while, and not just because of the GDPR, but there are a number of data transfers that just haven't been a good fit for the existing model clauses, and that's why they're being updated. So this is a case of not letting the perfect be the enemy of the good. For US data controllers that still need to think about GDPR data exports from the EU or the UK, you need to put some sort of modified version of the existing model clauses in place now to have a form of data transfer mechanism in place, even if it isn't perfect. The simple fact of the matter is that when the new modular model clauses come out, they will take into account and they will be a much better fit for non-EU data controllers. They're going to be a much better fit for a number of other situations. They will also still have to fit alongside your existing Article 28 DPA clauses. Those Article 28 terms have the potential of conflicting with the model clauses. So no matter which version of the model clauses you're putting in place, it's really important that you look at those model clauses, you look at how they fit with your existing DPA Article 28 terms, and make it very clear that the model clause terms where they might conflict with the DPA, the model clause terms are the ones that are going to govern. So you need to think about your business practices and how they fit with those model clauses that you're putting into place.
What are some approaches to implementing the new SCCs by the EDPB, assuming those get approval? For example, could it be an addendum to existing SCCs, or should they be entirely rewritten?
So if you're amending legacy contracts anyway through some form of addendum to the commercial agreement, then it makes sense to put the new SCCs in place rather than simply bolt them on to the existing SCCs. I think this is a cleaner approach, and there are a number of advantages to taking that approach. From an accountability perspective, it'll be easier to demonstrate compliance, because if a regulator were to pick the document up, it would be easier to see that the new requirements were addressed. For example, while the existing controller to processor model clauses envisage the listing of security measures, the new draft SCCs set out recommended security measures. So it makes sense to present the security measures in a way that closely reflects the recommended ones. And taking the cleaner approach will also make it easier to understand where conflicts may arise with existing commercial clauses. That said, we are seeing some organisations seek to future-proof their existing arrangements with drafting references to existing SCCs being replaced by the new ones in due course. So it very much depends on the nature of your relationships and when you are seeking to put the new standard contractual clauses in place as to the particular approach that you would take.
I hope you've enjoyed those questions and answers. As I say, if you sent in a question and we didn't manage to get to it, we will be looking at those in our YouTube videos that come out regularly every month. The next thing to say is that we've also issued today our data protection times, so please take a look at that. That's our review of the year that was, and in a newspaper format. And finally, just a bit of a sneak preview. One of the questions that was raised was an interesting one about legislation in the UK. It was, until the legislation.gov.uk website updates its DP legislation, are we meant to work from the two Keeling schedules on the publishing service Gov UK site? So read the DPA 2018 and the UK GDPR together. I think unfortunately you are, and it's worse than that because you have to look at the exit regulations as well. But as a little bit of a sneak preview, we hope today to be issuing a tool that will help us all. It will put in place on a website the UK GDPR, so it's easy for us all to refer to that properly without having to try and construct it from a Keeling schedule. So keep your eyes peeled for that. Thanks for your time. Please do log in and have a look at our blog and our regular webinars and also our YouTube sessions. And see you soon. Thanks.